There are a handful of other staffing laws that we should be aware of, and one of the most important, and we should be very familiar with, if anybody who's ever had a job should be familiar with, is the Immigration Reform and Control Act of 1986. And in this law, um, it prohibits employment of unauthorized aliens. So basically, it means people who are here illegally and who are undocumented. They don't have the right to work here in the country. And so there are penalties for doing that. And this, in order to manage this, we have what we call an I-9 form. And that I-9 form, every employer must provide it to individuals and use that form to be able to demonstrate whether or not someone is authorized to work here. We accept we accept the information that someone gives us on face value. It's not our responsibility to go, I think they're lying about their Social Security and therefore I need to investigate it. That's not our responsibility. Our responsibility is to accept the documentation, assuming that it looks legitimate, and to accept that and to document it accordingly. If we document it accordingly, then the government doesn't come after us for that. They still will go after the person who is falsifying documents or things like that. We would not be held responsible as the employer. So who enforces this? The Department of Justice does. And if we don't comply, it's $10,000 per person. So if you have a staff of 100, then you're going to end up with that problem as well. Another staffing law that's relevant to us is the Employee Polygraph Protection Act. This act prevents most private employers from using the polygraph for a job applicant or an employee. There are some exceptions to it, which I won't go into, but generally speaking, employers cannot use a polygraph as a selection tool because it doesn't predict job performance on the job. And we know that polygraphs have errors in them. Now, can we use a polygraph as evidence? Possibly we can. And I have worked in an organization where we've asked employees to take a polygraph test. And it doesn't necessarily mean they didn't do it, and it certainly doesn't mean that they did do it, but it does say that we should investigate further. So the goal of the polygraph, is just maybe a piece of evidence that we use to dive in deeper to determine whether or not someone actually performed a bad act, whatever that might be. In my situation, it was they thought it was an embezzlement issue, and they ended up figuring out what the problem was. But given that that money had disappeared, they needed to do some investigation to figure out what was going on and why. So, it's prohibited to require applicants to take the polygraph. It's prohibited in using that polygraph to make your employment decision, and you cannot discharge or discipline somebody for refusing to take a polygraph. Now, if people do it voluntarily, that's great, but you cannot fire them for choosing not to. They do not have to do that under the law. Again, also enforced by the Department of Labor, and the non-compliance is $10,000 per incident. The next is the Fair Credit Reporting Act of 1970, and this regulates an organization's acquisition and use of consumer reports on job applicants. So basically it means you go work for an organization, they might ask you for a credit report or to do a background check that includes a credit check. Why might that be important? Well, if you're working with money, if you're working in a bank, then it's a relevant thing to know. If you are somebody who has a lot of debt, then you're at risk for embezzling or stealing money from the company. So it is very limited, though, and when it can be used, it cannot be something that everybody uses. And specifically, you need to have written authorization from the applicant before you do that credit check or background check. So you have to give them notice that that this information is going to be obtained, and you have to get their written authorization to do it. If an adverse action is taken because of the contents of that report, the organization has to notify the applicant of the adverse action. You were not hired because you have a really bad credit to debt ratio. And that information gets reported to the applicant about which agency, like whether it's Equifax or whoever did the investigation, and which credit report you used, and notify them of their rights and what they can do. If there's a problem on the credit report, they have the right certainly to fix the credit report and to be reconsidered for the job, but they need to know what those things are. And the same thing, this is covered under the Federal Trade Commission, not under the EEOC or Department of Justice. It's under the FTC, and if you don't comply with this, the fines are minor. It's $1,000 per incident, but it could add up if you continue to do this across the board in an illegal way. Lastly, you need to be aware that state and local laws are different than the federal laws. In many situations, we might have no federal law that addresses an issue, but state and local laws may address something. State and local laws are often patterned after federal laws, and a great example of this is the Age Discrimination in Employment Act. We have a federal law, but we also have state laws that can actually be stricter than the federal law. So they might be broader in terms of the age ranges that they require. They may be broader in terms of what is considered discriminatory and what the remedies would look like. So there's a whole host of different things that can occur under state and local laws that may not be addressed under federal. And so anybody who has a complaint should obviously investigate, is it better for me to draw my complaint in federal court or state and local courts? And that's part of the determination that you make with your attorney about what is the best venue in which to put forth your claims of discrimination. They often can provide protections beyond what federal law says. So that's always a kind of a good thing. Other laws you should be aware of: employment at will, which means someone can be fired for good reason or no good reason at all. The bottom line is, if I don't want you to work here anymore, I can just let you go. Now, there are some limitations to firing people, and we'll talk about that when we get to later chapters. But just know, generally speaking, employment at will basically says unless you're intentionally, and we have evidence that you're intentionally discriminating against someone, we have the right to let people go for any reason or no reason at all. Now, the opposite side of this coin is employees can leave for good reason, no reason. They can leave at any point in time. They don't even have to give notice if they don't want to. Now, is it good faith to do that? Of course. Is it good manners to do that? Yes. But we don't have to under the law. So always remember, right, what we should be doing ethically and what we can do legally are often very different. Workplace torts. Other workplace torts, like, for example, if someone defames me or harms me in some way that's not criminal, they take my things or, abuse me in some way, these are workplace torts, and those can be handled, in a different manner, than necessarily going through an employment law situation. Other things, criminal records and criminal record inquiries and what we can or can't do are important. Polygraph and honesty testing is also really important, but we have to be careful about the polygraph based on what we just talked about before. Drug testing is important, and we have some limitations on what we can and can't do with drug testing. AIDS testing, which is probably less relevant now, but was a bigger issue maybe 20 years ago. And then the ability for employees to access their personnel records. They have the right to access their personnel records, whether or not we like that. So we also should be very careful in what's in those records, what we say, and how we say it, because if we are not conscientious about what we put in those records, that can come back to bite you if you've engaged in intentional or unintentional discriminatory behavior. So, make sure that we are putting in relevant information and truthful information, so that we don't get ourselves into any kind of legal troubles doing that.